the player that gets that on the opposition side who is involved in the supposed high tackle or concussion, he stays on the field, gets up and carries on playing, nothing wrong with him. And the offending player gets sent off the whole game.
Okay, let's get started for today. This is a related shaila about going to a beis din versus going to secular court. And there are certain circumstances where, since you're dealing as far as who's going to actually be the responsible party for payout is the insurance company. That's what we learned last time. Then under certain circumstances, you're allowed to go straight to secular court, even though you're suing a frum Jew, but you really, his insurance company is really taking the lead on the case, and therefore you're allowed to sue them in secular court. That was the conclusion of Rav Sharaga, and there's certain things that have to be fine-tuned. So here's a sort of a follow-up question: the inyan halicha lebeis hadin la'avodah. Like, can you go to the what did we call it, Marvin? The work labor court, labor board. Okay. In other words, if you feel that an employer is mistreating you, what is your legal recourse? Is that you go to the labor board? Okay. All right. So let's see how the system works in Israel. Avadati b'makom mesuyam v'hama'avid heirat t'nai ha'avodah sheli. I was working in a certain place, and the employer caused made the working situation worse than it had been previously. Ismanti oto. Now he doesn't explain what the circumstances were. It could be he reduced my hours. It could be that he took away my coffee breaks or whatever it is. Ismanti oto l'din Torah v'hulo ofia. I sent him a hazmana to a din Torah, and he didn't appear. Beis hadin kasvo lav ksav seruv v'hitiru li lefanot lebeit hadin la'avodah. So the beis din basically wrote a seruv. This guy has refused to come to court, and they gave me a heter to go to the labor board. Okay, beis hadin la'avodah chiyev oto b'pitzuyim ushar hatavot sheyesh bein oved lema'avid. So the labor court, it seems more than just a board. It's like a beis din for labor. They obligated him to pay pitzuyim, which I think is damages. Ushar hatavos sheyesh bein oved lema'avid, and they obligated him to provide further benefits that is expected between an employer and employee. Uvenosaf lekach chayev oto b'halona schar sikum nichbad shel kesef. And as a result of him not paying me in a timely fashion, they also assessed a fine, a penalty on him. Is it permissible for me to take this money according to halacha, or is perhaps the court's assessment excessive, and it wouldn't be pitzuyim as compensation, right? That she puts in pitzuyim is compensation, and so basically, my boss they had cut my salary, so then basically they obligated them to pay all of what they owed me, and all of the back pay that they hadn't paid me, they assessed a penalty on that also. And so is it permissible for me to accept that money? So here's the tshuva. Hagimara omeret b'masechet Gitin Tanya Hara b'tarfan omer kol makom sha'ata motze agoriot shel akum. He says anytime that you find secular courts or courts of heathens, afal pisha dineim kidine Yisrael iyata rashai lihizdakek lahem shenemar ve'ela mishpatim asher tasim lifneihem lifneihem velo lifnei goyim. So we've seen this before, that there's a seemingly either a biblical or perhaps just a rabbinic obligation to not go to the Gentile court. asher danam bo al pi chukei hagoyim v'higdiro so ke meirim yad b'toras Moshe Rabbeinu chas v'shalom. We also learned this. They said it's very, very wrong to go to secular court, and it's as if you're lifting up a hand against the Torah if you do. Because of the Midrash Agada shows the Kain in lochelek leolam haba, the kafar belokei Yisrael, kevin shemekabel marusim shel chukei umos haolam umoas bedina Yisrael. Here also he brings a medrash that says you lose your portion in the world to come, and you're a denier in the God of Israel, since you have accepted the authority of the other nations over yourself and have rejected the laws of Israel. The Isser Zeh Kayam Afke Shishnei Hatzadim Mitratzim Umekablim Aleim Et Maru Dinei Hagoyim. This prohibition is true even when both sides accept the ruling of the Gentile court. The Kol HaKesef Sheyikabel Shelo Al Pi Din Torah Lo Yavriach Mizeh Klum V'Harbe Drachim LaHakadosh Baruch Hu Lahotzi Et HaKesef Miyado Ulahachziro LeBa'alim B'derech Acheret. He says, and any money that a person is awarded in a secular court that rules against the rules of the Torah, the winner will not benefit from that money. In other words, he's not saying you can't take it. He's saying if you are awarded that money, God will find ways to take that money away from you, okay, and figure out how to return it to its rightful owner. Kemosha HaGemara Omeret b'Maseches Sanhedrin ki ha-mishpat le'elokim hu. The Gemara in Sanhedrin comments on the verse that justice belongs to Hashem. Amar Rabbi Chama b'Rabbi Chanina, Amar HaKadosh Baruch Hu lo dayan l'rishon shenodlan mizeh mamon ben ostin lazeh shelo kedin, ela shematrichan osi lahachzir mamon leba'alav. It says, the Gemara says, it's not bad enough that the wicked end up causing the wrong people to receive ill-gotten gains, but they also are matriach me. They burden me, God, to make sure that everything is restored to where it's supposed to go. That's the way the Gemara views it, is that even if you act improperly and you end up extracting money in court that is not rightfully yours, Hashem will have to figure out a way to restore it. V'chein pirush Rashi sham beGemara dim adam motzi kesef mechaver shelo kedin Torah zenechshav kilu motzi kesef meHakadosh Baruch Hu shre'elav lahachzir mamon leba'alav. And that's the way Rashi seems to explain it, is that if you extract money unfairly from another Jew, then you're causing Hashem to have to figure out a way to return the money to its rightful owner. But he says over here, there's a specific court that's in charge of adjudicating differences between an employer and an employee, employer-employee relations. Dihine HaMishnah Omeret Bevava Metzia, the Bedine Schiras Po'alim Kaimalan Hakol Keminak HaMedina. He says maybe there's a difference here when it comes to employer and employee rules, because everything, says the Gemara, when it comes to hiring workers, you have to follow the Minhag HaMedina. Now, what does that mean? That if the Minhag HaMedina requires certain coffee breaks, right, or certain working conditions, then you have to abide by that as a member of that place. And therefore, there's a good argument to be made that going to that kind of court, where the court is going to assess the standards of the local, standards, they're going to assess whether those standards were met or not. So really, they're just upholding the Minhag HaMedina. B'kol makom ein lalechet ladun sham, kevin shahashoftim sham danim gam al pi ha-normot ha-mekubalot b'vatei ha-mishpat, v'gam lo makpidim al edim kisherim. However, he says, you still shouldn't go there. When you're taking let's say your employer is a frum Jew and you're a frum Jew, he says, because the judges there are judging gam al pi hanormot hamikubalot bevatei hamishpat. They're judging based on the norms that are accepted in the secular court, and they don't concern themselves with kosher witnesses. Umekablim eid echad umechayvim ribios v'hatzmados. And furthermore, they accept the testimony of one witness who would not necessarily be reliable in a beis din, And they also assess penalties that are based on interest charges. So let's say, for example, an employer had not paid what he was supposed to an employee. The court would assess, okay, so you owe the employee X amount of money in back pay plus interest. And interest, you're not allowed to pay interest or accept interest if from one Jew to another. Let's see. And they also basically, right? So, and Hatzmadot, I'm not sure what that means in this context, but I guess additional penalties. V'rov hashoftim haskalatam hi chukei ha'erkaot v'hei nimtzaim b'achrayut hanhalat batei hamishpat v'lo kfufim l'dinei Toratenu hakdosha v'lachein b'derech klal asur ladun etzlam. And therefore, the majority of the judges base their ruling on the secular law, and they have to abide by certain norms of the secular court and by the certain ordinances that the court imposes, and they don't go according to the laws of the Torah in the way that they gather evidence, in the way that they assess fines and so forth, and therefore it's better not to go to them.
There's a lot. Not just labor, there's also landlord tenant, there's pension, there's.
It seems that whatever he's saying here would apply to all other cases as well. He says, Omnam, however, in this case, remember what had happened. The employee sent a hazmana to Basin to his employer. The employer blew him off. Okay? Omnam im kibel heter mi Basin musmach, muter lo lifnot le'erkaot lahatzil mamanu chadesh lo yehi echotei niskar. But since once the Basin gives you a heter to go to court, then you are allowed to sue your employer in a secular court so that you can retrieve what is rightfully owed to you. And also, it's almost like we learned before, it's a penalty on someone who refuses to go to Basin. We sort of throw you to the lions in the sense that even if they're going to assess more penalties on you than you would normally have to pay in Basin, but that's the price you have to pay for refusing to go to Basin. Well, let's see. Rashai hatovea lekabel kol ma sheyachayvu et hanitva milvad hadvarim shenogdim et dinei Toratenu hakdosha. He says you're allowed to accept everything that they obligate the defendant to pay, the employer to pay, except those things, like Paul was suggesting, that are in direct opposition to our Torah. Kigon ribiot, atzmadot, v'halanat schar. So he says ribis, okay, so if they charge an interest because they say that you owe, the back pay plus interest, you can't accept the interest. Halana schar, that if they impose a penalty for him failing to pay you in a timely fashion as an additional penalty, you're not allowed to accept that. Sha'asurim, let me bring up the next one. Sorry. Here we go. Sha'asurim al piha halacha. Below omrim bazeh dina de malchus adina. And we don't say, therefore, on certain things that are clearly in opposition to the Torah, that dina de malchus adina. So if the court assesses interest payments, so then you're not allowed to accept the interest. What you are allowed to accept is you're allowed to accept any expenses that you incurred because of this guy's refusal to go to Basin. Now, so let's consider for a second. If we would have gone to Basin, I wouldn't have had to hire a lawyer. I wouldn't have had to pay the court fees. Now, the court might not award that to me. So the question is, can I offset the penalties and the interest payments In
Say, well, that's not interest, that's just money to pay for
Covering my
it.
costs.
that's covering my costs.
So realize that they differentiated. Just like, because I didn't get my pay in such and such a time, I mean that I couldn't do this, or I couldn't do it. Like, I mean, interest is there to try and.
I don't think that counts as a damages. It's not right. If I didn't have the money that I was counting on to, let's say,
They can say paying off your mortgage. So,
Yeah.
so all of a sudden you've got added cost to your mortgage because
right,
you didn't get your pay on time.
right, that seems to be a causative damage in halacha. That's not something that a person is able to really collect on. Because I didn't have the money in the bank, I had to borrow money and pay interest on it. That I don't think you can assess that on the person. I don't think so. I don't think so. He does say in the footnote over here that Hine pasak hashulchan aruch hamitchayev bedin eno chayev l'shalim l'shekenegda v'yitziotav. He says that if you are found liable in based and you're found to be guilty, you're not liable to pay the plaintiff's court fees. Even if he made you schlep to another based in another city and that you definitely have expenses. V'hani mili delo misarv l'meikam bedina ela shirot saladun be'ir acheres. But that's only when both parties agree to adjudicate in another city. Aval im hayem misarv lav l'beistin v'hutzrach hatovei lahotzi hotzos lakufa leirid ladin chayev lifro lo kol hotzosav. But if the person that you went to court with was refusing to go to court, and you had to use additional funding to coerce him to come to court, let's say you had to agree to travel to where he wanted to judge, okay, then he ends up losing, then he has to pay your expenses. V'yesh misha omer shim tavu be'erkos v'hotzi hotzos b'dayonim v'toanim afal pisha mitoch siruva hutzrach laholichu be'erkos eno chayiv l'shalem hotzaosa. But there is an opinion that says that if a person refused to go to Beis Din that required you to take him to court, you cannot coerce him to pay for your court expenses. Because of Sham HaRama, and the Rama writes, V'yesh cholkim l'svir lehudim hutzrach lahutzi lahotzos lakupa de'arko shel akum chayiv l'shalem lo v'chein nira li'ikar ulvad shaso b'rshos Beis Din ad kam l'shana. The Rama disagrees, and the Rama is of the opinion that because a guy refused to go to Beis Din, I have to take him to secular court. And as a result, I incur additional expenses, because let's say the Beis Din would have charged X. And now going through secular court, it's X times something. It's usually much, much more money to go to a secular court because you have to hire lawyers and stuff like that. Then you can collect on court fees, provided that the Beis Din gives you permission to go to the secular court. V'ayin bebeis Yosef sham shekos b'shem harosh shegamim kofei ladin be'erkos kishahanitva lo tzayis dina chayiv hanitva l'shalim lo hotzaosav. Simar bebeis Yosef dahachi mistaber. He says, and the Beis Yosef writes in the name of the Rosh that if someone compels you to go to secular court, and because let's say the defendant is not agreeing to go to Beis Din, then whatever costs you incurred by going to secular court, then the defendant if he loses, he's going to have to pay you for your expenses. And the Beis Yosef says that seems to be the case. Nimsa de das moran lepos lifso kamo hayesh cholkim shehi arama. Okay, basically he's saying that I believe his argument is, as a Sephardi posek, that he believes that the Mechaber agrees to the Rama, and therefore it is permissible for you to extract court costs. Now, what's not clear is like I asked, can you offset the penalties and interest to cover the court fees that the court did not award you? So I don't have an answer to that. But let's see how he continues the tshuva. I believe they charge by the hour. They take an initial deposit, and I don't remember but you're paying 3 dayanim an hourly fee. It could be thousands of dollars. It depends on the case. Sometimes cases take several days. Often, yeah. The dayanim, in certain cases, if they feel that the plaintiff's case was frivolous, or they feel that there was flagrant wasting time or criminality, they can assess the losing party a knas. Yeah. So yeah, we had that situation years ago when the court ruled in our favor, that trust case that I told you about. They did assess that other charity court fees as well, because they felt that the lawsuit was frivolous, completely frivolous, and so it was a big busha for them. Well, they only know that it's frivolous after they've examined it, you know. Yeah. No, that's the norm. That's the normative halacha. You don't have a right if both of you have agreed to go to a specific beis din, and then whoever prevails cannot demand court fees. Even yes, and therefore, so certainly that's true. A lot of times, let's say a person will be sued unfairly. Let's say a person is taken to court and they go to beis din, and the defendant wins the case. The court finds him to be not liable to pay, right? So he's furious. Like, he wasted my time. It took me to beis din. I had to pay all of this. Cost me money. So sorry. Yeah, that's just the way things work, right? Every citizen, every Jewish member of the Jewish community has a right to take the other party to beis din and let the beis din decide what the ruling is. But you're not entitled to recoup your losses for having gone to beis din. Well, there's a small preliminary, sort of just, let's just give me the facts. What were you suing? Why are you suing him? And generally speaking, the beis din does not have a right to make a decision that, based on the preliminary. They do have to have a hearing. Before what?
Before we have a beis din case to say.
So who's making the peshara? The litigants have to.
I was happy with it. We actually have to hear it.
I mean, that's up to the discretion of the beis din.
Right.
It's not normative for a beis din to say, can we try for a peshara before they even hear any case? Like, why would you expect the beis din to do that? Yeah, I mean, I take a guy to court because I think he owes me $100. I would be probably pretty miffed if the beis din says, without hearing anything, why don't you just take 50? No, the answer is because he owes me 100.
Right, that's always the way with an argument.
No. Yeah, you have to hear something. Yeah, you have to hear something. Right. It's right. No, the beis din's not going to do that. Now, if they're part of the same, if they go to the same Rav, and the Rav says, look, this is there is definitely what to adjudicate in a Beis Din. I hear that there's two sides to this story, and I think you should go to a Beis Din and have the Beis Din paskin. The private Rav may say, or if you wish to avoid the expense and the time off, you could come to a compromise on your own. So why don't you guys try to work it through? Right? That's for a private rabbi to try and advise. Yeah.
It's a chamber.
If you decide the death sentence, seem bleeding, I suggest you go outside and try to resolve it and come back when you're ready.
Right.
And then see
There
that.
you go. There you go.
If the amount in question is small and the cost of rate, may well be just
Yeah. No, I usually tell people, sometimes people get really upset because they've been taken, but
emotion.
it becomes emotional, even though like the amount is, let's say, a few $100s. And I say, you're right. The guy looks like the guy scammed you. But what are you going to do? You take him to Beis Din, it's going to cost you more than those few $100s to get justice, right? Okay. Yeah, well, sometimes no. And by the way, I definitely hear that also. I don't want this guy to scam other people. I'm not going to let him get away with it. Yeah. Okay. So v'hinei b'sefer piskei din rabbanim Yerushalayim kasavnu lahatir ba'ofanim mesuyamim lifnot lebeit din la'avoda. Now, there's a sefer called Piskei Din Rabbanim Yerushalayim. I'm not familiar with that sefer. It must be it's a series of Piskei Halacha that were made by Jerusalem rabbis. And I wrote in one of those volumes that under certain conditions, an employee could go directly to the labor court. V'shekain hiskim imanu hara avad hagri kolitz zatzal. And this other great Yerushalayim rabbi agreed with me. Utshuvatenu hanal shuv nitfeset b'shut v'haya ha'olam ayin sham. And the response that I wrote has been reprinted in another sefer. The udvarenu hanal huvu b'shut sholin b'dorshin v'hiskim imanu lahalacha. He says, and this also appears in another sefer. Ubizman shekatavnu et hapsak hanal hiskim imanu hagon Rav Avraham Shapira. Zatzal harav harashi l'Yisrael ubeshulei dvarenu hosif bazeh halashon. And after agreeing with my psak, under certain conditions, you are allowed to go to the labor court. Rav Avraham Shapira, who at the time was the chief rabbi, wrote as follows: Gam ani, I think the chief rabbi of Yerushalayim. Oh no, the chief rabbi of Israel, Rav Avraham Shapira. He says, Gam ani mitztaref lahomer b'psak hanal shelagon moharenu Rav Yitzchak Kolitz Shlita, Harav Harashi L'Yerushalayim, V'shel Harav Hagon Baruch Sharaga Shalita, Chaver Beit Hadin L'Mamanis Be'er Kodesh Yerushalayim Tiboneh V'Sikonei. He says, I agree with the psak of Rav Kolitz, who was the chief rabbi of Yerushalayim. I agree with Rav Sharaga, who is the author of what the sefer we're reading, and he's also a member of the Beis Din for mammon, for money in Yerushalayim. Shehitiru la'obed litvoa mima'avid tviat pitzuyim beveit hadin la'avoda, that it is permissible to take for an employee to take his employer to labor court. Al smach psak din she'evi hagon Rabbi Kiva Eger ba'hagos Choshen Mishpat shamuter ladun b'sichsuch shel socharim lifnei Beis Din shel socharim. Rabbi Akiva Eger says that if there's a specific type of industry, and there's this court that deals with that specific kind of industry, then two members of that industry can sue each other in that kind of court. Yeah.
So how does that define? Because I mean, there's an employment. So the common court for employees.
Yeah, it seems that it would. Let's see where he takes this. And in this situation, the minhag hamakom will override the normative halacha, because basically, I guess when you enter into that industry, it's implicit that if there are going to be disputes, you arbitrate those disputes in a certain venue. V'nidon didan litvo pitzuyim adif tfei. And certainly that's true if the employee is trying to recoup compensation. Shahatam yesod haheter hu lagabi chiyuv mamun shel socharim שהתחייבו מדין תורה, והמנהג בא לשנות את ההלכה, שהדין על כך ייתכן שיהיה בבית דין של סוחר. He says, the whole heter is Yesod haheter hu legabe chiyuv mamun shel sochrim shitchayvu midin Torah. And he says, in a situation where the minhag of this industry is different from the laws of the Torah, Rabbi Kiva Eger was permissive. Aval benido didan ein chiyuv mamun klal midin Torah v'rak mikoach minhag notzer chiyuv l'shalim pitzuyim. He says, but in our situation, there is additional compensation that is due to the employee that is completely unrelated to Dinei Torah. That seems to be what he's saying. ואז יש לומר שלכולי עלמא אותו מנהג שקבע את החיוב יש לו תוקף לקבוע שגם הדין במנהג החיוב יברר בבית דין של עבודה. And therefore it's even more logical to state that when there's a certain standard that is completely outside the boundaries of what the Torah would obligate an employee, then it makes sense that you should be able to take this guy to a labor court. Let's say minimum wage, something like that. You're paying someone less than minimum wage, and he feels he's entitled to minimum wage. There is no minimum wage in the Torah. So that would be something he wants to argue that you'd be even more entitled to go to a labor court because it's completely outside the purview of Dinei Torah. Let's continue this in Mirza Hashem tomorrow. It's already late. Just remember, Talis and Tefillin is not until like 6:51, something like that. You'll find out when you get inside. Have a great day, everybody.